The most common question that I get is, if my spouse dies, do I have to file a probate for them? And what does community property mean? Today, I'm going to give you the answer to both questions. And I'm going to tell you in advance, there are 5 exceptions to having to file a probate in the state of Washington, and I'm going to tell you about each of them. Hi, I'm attorney Chris Benson. I've been an estate planning, probate, and bankruptcy lawyer for the past 30 years. In today's video, we're going to address the most common questions that I get in my probate practice. And that has to do with when a spouse dies, do you need to do a probate or not? And I'm going to tell you about the 5 exceptions. And I'm also going to tell you about what community property really means. The answers might be a surprise to you, just like they were to my client Lucy yesterday when we met concerning her husband passing away last month. Before we get started concerning the answer to the questions, I want to tell you about something in the state of Washington. And that is, you can file a probate in any county regardless of where the deceased person resided and regardless of where the personal representative also resides. That's one of the nice things about doing a probate in the state of Washington. We have clients who are personal representatives who live all over the world. The person who died was a resident of Washington and owns real estate in the state of Washington. But you can live anywhere and be able to hire the best lawyer for your case. Question number 1. Do I need to file a probate for my spouse who's died in the state of Washington? The answer is yes, unless one of the following 5 exceptions applies to you. Exception number 1. If the real estate is owned by a trust, then the trust does not die and the assets are transferred pursuant to the trust agreement to whoever the named beneficiaries are. So if the real estate's owned by a trust, you don't have to file a probate in the state of Washington. Exception number 2. If the property is held as joint tenants with right of survivorship, in that situation, all you need to do is record the death certificate in the county where the property is located. I can tell you in the state of Washington, it's really rare for real estate to be owned as joint tenants with the right of survivorship. In other states like Arizona, it's very common. In Idaho, it's very common. But in the state of Washington, it's really rare. And when you originally obtain title to the property, it has to specifically state joint tenants with the right of survivorship. If it says husband and wife, that's not good enough, and you need to do a probate if it just says husband and wife. Exception number 3. If the account has a payable and death beneficiary, it's really common for life insurance, retirement accounts, 401k, SEPs, IRAs, deferred comp. Those are really common to have payable and death beneficiaries. So those would pass outside of a trust and outside of a will, and they go directly to the named beneficiary. Exception number 4. If you have formally executed a written document called a community property agreement prior to the person passing away. I can tell you that they are unique to the state of Washington, and they were very common back in the 1970s and the 1980s. Since I've been in practice for the past 30 years, I have never completed a community property agreement. There's lots of reasons for that are beyond the scope of this video. But if you are lucky enough to have a community property agreement and it was signed by both the husband and the wife or both spouses, then all you need to do is record the community property agreement and a certified copy of the death certificate after the person passes away. And in that situation, you don't have to do a formal probate for the person who died in the state of Washington. Exception number 5. If the person died does not own title to any real estate and the cumulative value of all of their assets is less than $100,000, then you can use the affidavit of small estate to handle and administer those assets. Washington is really unique in that the value has to be less than $100,000 and you can't own any real estate. Other states are different. For example, the state of Oregon has a higher limit, and you can also own real estate as long as that real estate isn't over a certain dollar amount. Each county in the state of Oregon has their own unique forms that you can use for a small estate if it complies with those requirements. But in the state of Washington, you can't own any real estate regardless of the value. So that's the 5th and final exception. If one of those exceptions does not apply to you, then the answer is yes, you do need to file a probate in the state of Washington. And that's where I get a lot of confusion and a lot of questions from the surviving spouse. And that is, well, I thought Washington's a community property state. Don't I just get everything automatically? And the answer is twofold. Yes, Washington is a community property state. Does the surviving spouse get everything automatically? The answer is no, and I'm going to tell you why. Washington is a community property state, but most people don't know what that means, and they frequently get it wrong. So I'm going to tell you what it means. It means that if I'm alive and I'm married, and we acquire assets during the course of marriage, it is presumed to be community property. That means spouse 1 owns 50%, spouse 2 owns 50%. It's a 50-50 title holding, okay? So if the spouse 1 wants to sell the real estate and spouse 2 says no, well, you can't sell the real estate because it's a deadlock vote, 50-50. Or if spouse 2 says, well, I want to take out a loan and use the house as collateral for that loan, and spouse 2 says yes, and spouse 1 says no, well, it's a deadlock vote, 50-50. It does not mean when one spouse dies that you automatically get the 50% of title from the deceased spouse. The deceased spouse can leave their 50% of title to whoever they want. And when you think about it for a minute, that makes complete sense. A lot of times in a blended family estate planning situation, we'll have a situation where one spouse will say, well, look, if I die, I want my share of the community property to go to my children. I don't want it to necessarily go to my surviving spouse. And the surviving spouse can make the same election. It's really common to see that in the state of Washington, especially in this day and age. Back in the 60s and 70s and 80s, it wasn't so common. But in 2023, it's really common to see that situation, and we do that type of estate planning all the time. The other thing about community property is it's a presumption. It doesn't mean it is in fact community property. It's possible that while you are married and while you are alive, that you inherit assets from a parent. It doesn't mean that when you inherit the property that it also belongs to your spouse. In fact, just the opposite is true. It's presumed to be separate property unless you commingle the asset with other community assets. Also, if you receive a bodily injury claim, the compensation for pain and suffering is separate property. It does not belong to the spouse. The spouse might have a separate claim for alienation of affection or whatever, but the person who is injured, the compensation that they receive is separate property. You can also receive a gift while you're alive from somebody else, and it specifically states that it is separate property. A lot of times I have parents who come in and say, well, I want to give a house to my child, but I want to make sure that their spouse is not on title. That's very common. We do that all the time. So just because you receive something while you are alive and while you are married does not mean that it is legally community property. It might be separate property. And that's what happened with my client this last week. Her husband inherited a piece of property while he was alive. He received that from his parents. They lived in the house for 40 years. He never put her on title to the property. Then he dies without a will. They also have 2 children together. Since he dies without a will, it's called dying intestate. In Washington, the intestate statute kind of says the following. It says if you're married and you die without a will, that the surviving spouse is entitled to 100% of the community property and 50% of the separate property, if any, and then the children of the deceased are entitled to 50% of the separate property as well. Well, that's exactly what happens in this case. Client's husband died. He had real estate that he inherited from his parents a long time ago. They lived in the house for 40 years. The person dies without a will, so the intestate statute applies. So regarding the house that they've been living in for the past 40 years, the surviving spouse is entitled to 100% of the community property, which means like bank accounts, things like that. But the house that they lived in was separate property because he never put her on title. Therefore, she's entitled to 50% of the house and their children are entitled to 50% of the house. We have to do a formal probate in the state of Washington. We have to send notice to everybody, including the children, and they have the right to 50% of the house, just like their mother. That answers the most common question that I get every week. Do I have to file a probate for my spouse? And what does community property mean? If you don't want an unintended result to happen, I highly recommend that you hire an estate planning attorney and prepare the necessary documents so that your family doesn't have to go through a probate, and also title of assets go to your intended beneficiaries. I'm attorney Chris Benson. Thank you for watching this week's episode on our YouTube channel, Listen to Your Lawyer. If you have any additional questions, feel free to email me. My email is available on my website. Take care.